You may remember our conversation last year when we discussed the Supreme Court's decision in Warner Chappell Music versus Neely, which somewhat adopted the discovery rule. Now, the discovery rule basically means that a plaintiff can sue for infringement within 3 years of discovering an act of infringement, even if that act occurred earlier than the 3 year period. I say the court somewhat adopted the rule because the majority opinion in Neely acknowledged that it has never decided whether a copyright claim accrues when a plaintiff discovers or should have discovered an infringement, rather than when the infringement actually happened. And in a dissenting opinion, Justice Gorsuch said that the discovery rule has no role in copyright infringement cases, absent a finding of fraud or concealment by the defendant, and essentially invited another case squarely presenting the question whether the Copyright Act authorizes the discovery rule. Is Rad Design versus Michael Greco Productions just that case? I'm Scott Hervey of Weintraub Tobin, and I'm joined today by my colleague and frequent briefing guest, Tara Sattler. We'll be talking about a cert petition filed with the Supreme Court asking for a ruling on the validity of the discovery rule on today's episode of The Briefing. Tara, welcome back to The Briefing.
Thank you, Scott. Thanks for having me again.
Yeah, this is going to be an interesting, I think an interesting topic. We've talked about we did a previous episode on the Neely decision. And I mean, there's been a lot of fallout, as we talked about, and as we predicted from this decision. So let's start with a brief summary of the facts of this case. So Michael Greco Productions they're a professional photography company. They sue Rad Designs for copyright infringement. They allege that Rad Designs used MGP's copyrighted photographs without permission. The central issue revolves around the discovery rule and its applicability in copyright law. Specifically, whether a copyright claim accrues when the infringement occurs or when the copyright holder discovers or should have discovered the infringement.
The case reached the Second Circuit Court of Appeals, which upheld the discovery rule, allowing MGP to sue beyond the typical 3 year statute of limitations if it could show that it only recently discovered the infringement. This ruling raised concerns about copyright trolling, as it could enable plaintiffs to delay litigation strategically and seek damages for years or even decades after the alleged infringement.
Right. And now Rad Designs has petitioned the Supreme Court for certiorari, asking it to clarify or reject the discovery rule, aligning copyright law more strictly with the 3 year statute of limitations from the date of actual infringement. Now, this case has drawn attention from various industries due to the potential implications for businesses frequently targeted by copyright claims over online conduct. Now, several NBA teams, including the Indiana Pacers, the Denver Nuggets, and the Orlando Magic, have filed an amicus brief supporting the petition.
The core issue here is whether copyright infringement claims can be brought outside the 3 year statute of limitations based on when the plaintiff discovered the infringement. Traditionally, under 17 USC section 507B, claims must be brought within 3 years of the alleged infringement. But courts have increasingly applied the discovery rule, allowing plaintiffs to sue long after the infringement occurred, as long as they claim they only recently found out about the infringement.
Right. And this case comes in the wake of Warner Chappell Music versus Neely, where the Supreme Court ruled that there was no time-based limit on damages for timely copyright claims, but left the discovery rule question open.
So let's provide some brief background on Neely. That case began in 2018 when music producer Sherman Neely filed a lawsuit against Warner Chappell Music, an artist publishing group. It was a run-of-the-mill copyright infringement case in which Neely claimed that Flo Rida's 2028 song In the Air featured an unlicensed sample of a 1984 track that Neely owned. The case became no such run of the mill when Neely's lawsuit headed to the Supreme Court to answer the unresolved question of whether damages in a copyright case are limited to just the last 3 years before the case was filed, or could damages go back beyond the 3 years? The reason why this case was ripe for Supreme Court review was due to a circuit split on this matter.
Right. The Second Circuit, which was the jurisdiction covering Neely's case, applied a 3-year damages cap that Justice Ruth Bader Ginsburg explained in the Supreme Court's past holding in Petrella versus MGM. A successful plaintiff can gain retrospective relief only 3 years back from the time of suit. No recovery may be had for infringement in earlier years. Profits made in those years remain the defendant's to keep. I mean, seems pretty straightforward. The Second Circuit applied the 3-year limitation on damages as set forth in Petrella, even in cases where a plaintiff alleges that its discovery of infringement was only recent. Despite the Supreme Court's apparent endorsement of a 3-year limitation on damages in Petrella, the Ninth Circuit and the 11th Circuit broke rank, and they held that if a plaintiff can prove that the plaintiff only recently discovered the fact of their copyright was infringed, not only can that plaintiff bring a copyright lawsuit outside of the 3-year limitation period, they can also seek damages going all the way back to the very first infringement, so well beyond those 3 years. So the question on which the Supreme Court granted cert in Neely was whether, under the discovery accrual rule applied by the circuit courts, a copyright plaintiff can recover damages for acts that allegedly occurred more than 3 years before the filing of a lawsuit, which the court then answered in the affirmative.
So as you mentioned in the introduction of this episode, the majority opinion acknowledged that it had never decided whether a copyright claim accrues when the plaintiff discovers or should have discovered the infringement, rather than when the infringement happened. And in a dissenting opinion, Justice Gorsuch essentially invited a direct challenge to the discovery rule.
Right. And so here we are. Rad Design's petition asks the Supreme Court to take up the question of the validity of the discovery rule. And the amicus brief argues that the discovery rule has become a tool for copyright trolls, companies and individuals who file lawsuits not to protect their creative works, but to extract settlements from businesses and content creators.
According to the brief, this has had a particularly strong impact on sports teams and entertainment companies. The NBA teams argue that they're being sued over social media posts that used copyrighted music in a completely incidental way, sometimes in clips more than a decade old.
Right, and that's a major concern. So the brief gives examples of where teams posted videos from games, and because background music from the arena was faintly audible, they were later sued. The plaintiffs in those cases used the discovery rule to claim damages for many years, even if those posts were available and visible all along.
So this also raises fairness concerns. The brief argues that businesses who actively monitor potential copyright risks end up at a disadvantage compared to those who don't. If you're diligent about checking for copyright issues, you might be limited to 3 years of damages. But if you claim ignorance, you could potentially claim damages going back decades.
That's right. And this contradicts the Supreme Court's reasoning in Petrella versus MGM, where the court rejected the use of latches as a defense, but assured that the 3-year statute of limitations would still control to the extent of damages. With the discovery rule in play, that assurance is essentially gone.
The amicus brief also highlights another important factor, the permanence of the internet. They argue that with tools like the Wayback Machine and automated copyright detection software, content never truly disappears. And yet, plaintiffs can wait years before bringing a claim, putting defendants at a serious disadvantage.
Right. And that's a crucial point. Evidence and witnesses disappear over time, making it harder for defendants to mount a fair defense and maybe establish that the plaintiff had actual knowledge. And as the brief notes, in some cases, plaintiffs, like Free Play Music, have deliberately delayed their discovery of alleged infringements to maximize damages.
So, what's at stake here?
If the Supreme Court takes this case and rules in favor of the petitioners, it could put an end to the discovery rule in copyright cases, restoring the 3 year statute of limitations as Congress intended and as interpreted by Petrella versus MGM. That would bring much needed certainty to businesses, content creators, and even social media users.
Right. And on the other hand, if the discovery rule is upheld, we could see even more aggressive litigation from copyright trolls, making it riskier than ever to post content online.
Right. This case could, and it will, redefine the landscape of copyright infringement litigation. And it will also finally determine whether courts will continue to allow old claims to be reviewed and revived indefinitely.
Well, Scott, this is really interesting. I'm sure we'll be keeping a close eye on this case and whether the Supreme Court grants the cert petition and makes a ruling.
Thanks for listening to this episode of The Briefing. We hope you enjoyed this episode. If you did, please remember to subscribe, leave us a review, and share this episode with your friends and colleagues. And if you have any questions about the topics we covered today, please leave us a comment.